I'll just leave it. I'm sorry.
All right. Mr. Peterson, we can talk off the record if you want, but real quick, do you have any felonies on your record?
For the OWI.
Just OWI, okay. And you're from Iowa, is that right?
Yep.
Okay. Do you have any, actually, I'd rather talk about it. I don't want to talk about it now, but for purposes of bond, I'm going to make a couple arguments that, but feel free to pipe in, okay?
Okay.
Because I'm not familiar with your history and whatnot, so I'm going to make a couple arguments about getting you out on a either a PR bond or a low cash bond. Would you be able to post a low cash bond?
I don't know where to get cash here.
What's that?
I don't know where to get cash here.
Okay. Well, it doesn't have to technically be cash, but like, could you post like $500 or so?
Yeah.
Okay, cool.
Good afternoon. The 93rd District Court will be in session. Thank you, Miss Matthew. Understanding that this is a little bit of a different situation. We've got an Alger County file that we're going to hear on a Schoolcraft County record. It's being recorded in Schoolcraft County. Miss Matthews here from the Alger County Public Defender's Office. And I know that the staff was waiting just to see about the availability of the prosecuting attorney. And we're ready to proceed forward. This is Alger County file 21-7-110FD, People of State versus Scott Howard Peterson. Can you hear me, sir?
Yes.
Are you Mr. Peterson?
Yes.
Okay, could you please state your full name, address, and date of birth, please?
Scott Howard Peterson, Jr., 509 Hall Street, Tama, Iowa, 52339, 13185.
Very well, thank you, Mr. Peterson. The complaint that's been filed by the people of the state, the Alger County prosecuting attorney, is a felony complaint that alleges that on or about July 30th, 2021, in Alger County, Michigan, in count 1, you did operate a vehicle upon a highway M28 while under the influence of alcoholic liquor, contrary to MCL 257.625. This is a misdemeanor in the state of Michigan that carries a possible maximum penalty up to 93 days and or a fine of up to $500 and or 360 hours of community service. Rehabilitative programs, vehicle immobilization may be mandatory with a prior under that statute, and you may be required to reimburse the government for the cost of prosecution, any emergency response or expense. Also listed in the same complaint is a third offense notice felony that's been filed asking the court to take notice that you, sir, were previously convicted of operating while intoxicated on or about April 23rd, 2013 in Black Hawk County Courts, Iowa, and of operating while intoxicated on or about August 17th, 2013 in Black Hawk County Courts, Iowa. Therefore, upon conviction under the statute, you'd be subject to an enhanced sentence under MCL 257.625. It's a felony in the state of Michigan, carries a possible maximum penalty of up to $5,000 in fines and either 1 to 5 years or probation with 30 days to 1 year in jail with at least 48 hours to be served consecutively, and or 60 to 180 days community service. Rehabilitative programs may be ordered under that statute. You may be required to reimburse the government for the cost of prosecution or any emergency response or expense. Also, Mr. Peterson, the court shall order law enforcement to collect DNA identification profiling samples before sentencing or disposition if they were not taken at the time of arrest. Do you understand the charge as I've read it and the possible maximum penalty?
Yes.
To that charge, sir, you have a number of rights. You always have the right to remain silent. Anything you say can and will be used against you in court. You also have the right to an attorney. If you couldn't afford an attorney, the court would determine your eligibility and appoint one at public expense. In this case, specifically the Alger County Public Defender's Office, and that's Ms. Matthew that we have joining us here. Is it your intention to hire an attorney, or are you going to seek court-appointed counsel?
Probably court-appointed.
All right, very well, sir. Just because of the logistics of how we're doing this today, would it be fair, Ms. Matthew, to allow Mr. Peterson to fill out the request for court-appointed counsel, and we can just proceed under the assumption that if he is qualified, the court would make an appointment of the public defender's office?
That's perfect, yeah. And we'll make sure to get that form filled out and given to the court. And if we could just go forward with a presumption that he will be appointed. If that is not the case, we could address that perhaps next week.
Okay. So, Mr. Peterson, you understand that? What we're going to do is we'll have you fill out an application today for court-appointed counsel. The deputies at Alger County will facilitate that. Ms. Matthew will review it, send it to the court. If you're eligible, you'll be represented from this point forward by the Alger County Public Defender's Office. It'll be your obligation to keep in touch with the Alger County Public Defender's Office, just as if you had retained them. And we'll operate under the assumption that that's going to happen moving forward. If at any point in time you decide that you'd like to go a different direction and hire your own attorney, then you may do so. Do you understand that?
Yes.
Okay. Mr. Peterson, you also have the right to a preliminary examination, which is a proceeding which must be held before the district court, which the people of the state or the Alger County prosecutor must provide probable cause to believe that a crime was committed and that you committed it. And pursuant to the court rule, we're going to set that preliminary examination for August 19th, 2021 at 8 a.m. And prior to that, you have the right to a probable cause conference. We'll set that for August 12th, 2021 at 9 a.m. And those will be noticed to you, Ms. Matthew, and to Mr. Steinhoff as well. Lastly, that leaves the matter of bond. Ms. Matthews, that's something that you wanted to address. I understand it's not been said in this file, but we could certainly accomplish that.
Thank you. So first of all, given the recent amendments to the pretrial incarceration statutes, there's a presumption in this case that he should be given a PR bond. As far as his criminal history, obviously I'm not familiar with Mr. Peterson, but my understanding is that he does not have any assaultive crimes on his record. I don't think he's a danger to the community. Obviously, there may be an alcohol component here, but one of the bond conditions will be presumably no intoxicants, including marijuana and alcohol. I think that should cover the community safety aspect. The other issue as far as appearance at further hearings, Mr. Peterson is represented by me and our office. We'll make sure that he has sufficient notice and that he's here. He is, I believe, from Iowa. However, given the ability that we now have to appear via Polycom or Zoom, I know that's not permitted in all circumstances, but I have had quite a few people who are up here on vacation who end up being charged with a crime who have been permitted to appear via Zoom, and it's not been an issue. I believe Mr. Peterson is entitled constitutionally to bond, to a PR bond, or at most a very minimal cash bond. He is an adult, he has a life, he presumably has a job and a family. Given the presumption of innocence and the recent changes to the pretrial incarceration statutes, I'd ask for a PR bond in this matter. Thank you.
Thank you, Ms. Matthew. The court obviously is familiar with what you're citing in the realm of pretrial release and that pendulum kind of swinging toward PR bonds when appropriate. However, that doesn't negate the fact that the court is still inclined to look out in the best interest of public safety moving forward. Now, I will say this, Ms. Matthew, the court has very limited information in front of it at this time. It has a charging document and nothing more. So I believe that your arguments are well footed in that regard. In the absence of a report, the court doesn't know if there's any other circumstances here that would be relative to the community safety. But what the court does have is an OWI complaint as charged with a third offense felony notice. So the court has to take an out-of-state defendant with, obviously at least 2 prior convictions for OWI and say, here we have a third offense charged within the 93rd district on M28, a highway in one of the busiest months for traffic that we can have. So in its sort of assessment of the case, I think that a bond here is going to be warranted. And I would encourage you, to raise the issue at the probable cause conference when at such a time more information is available to the court. Bond is always modifiable, but at this time I think that we have to all sort of sit back, the court and the parties, and say we have to find something in the middle of the road here. So the court will set a bond that I believe that Mr. Peterson could work at to post, or this could be reviewed at the probable cause conference on August 12th. But in the interim time, court will set bond at $20,000, 10%. That's again, modifiable at any point in time with the specific condition, no use of alcohol or illicit controlled substances. And in the interim time, as a condition of bond, standard condition of bond, Mr. Peterson would be prohibited from leaving the state of Michigan. And I'm going to leave that in effect until either Magistrate Mackey or Judge Luma decide otherwise as a standard condition of bond. So that'll be the court's finding on today's matter with the appointment of Ms. Matthew. And again, I would encourage you to bring that forward when the court has a full idea of the defendant's criminal history and employment status, family status, what the defendant is in the area for, if the defendant is going to stay. All those things would be relative in the court's mind, and we can address those at the probable cause conference. Is there anything further, Ms. Matthew?
No, sounds good, Magistrate Maddox. I appreciate it. And Mr. Peterson, I'm going to give you a call here when we're done, okay?
Okay.
All right, very well. Thank you, Ms. Matthew, and I appreciate everybody's understanding and sort of this, technology is good for what we're doing, but it is a little bit odd to be handling it this way. But we're able to get it accomplished today, so I thank everybody for their time. Court will be in recess.
And thank you.